Hi, this is Blaine Cluten for Cluten Law, answering two questions today. The first question is, how much does a will cost? And the second is, what does a will look like? The first question about how much does a will cost, that's going to depend on the attorney that's preparing the will document. Some attorneys charge wills on a flat fee basis, meaning it's kind of an all-you-can-eat. However long it takes them to prepare the documents and execute, they're just going to quote you a flat fee. Other attorneys work on a hourly basis, and depending on how many changes that are needed throughout the process of updating and finalizing the will, then that's going to add on more hours to the timeline, and you're going to end up paying more money because more hours into it equals a higher price. So the bottom line is it's going to kind of depend, number one, on the attorney's schedule, fee schedule, and then number two, how long it takes. And then a final note about price per hour, that's going to depend on the area in which the attorney is practicing, the geographical area, whether it's a major metropolitan area or an outlying area. Usually outlying areas, the attorneys charge a little bit less per hour. It's also going to depend on the attorney's experience. And if the attorney has spent a lot of time and their sole focus is on estate planning and they've been doing it for a lot of number of years, then you're going to expect to pay more per hour than a newer attorney that has less experience. They're typically going to charge a little bit less per hour. Also may make a difference about whether the attorney's at a big firm or working for themselves. All those are going to go into what you're going to anticipate paying per hour. The second question about what does a will look like, let me pull one up here. I've got one in front of me. So at the top, it's going to indicate that it's the last will and testament of a particular person. So in this case, just insert your own name. The next part is that the different portions of the will are going to be broken down into articles after naming the person themselves and where they're a resident of, and that they're revoking prior wills and codicils that have been executed and indicating this is their last will. There's going to be specific articles. There's going to be articles with, if they have any, there's going to be specific or general gifts. That is then further broken down, and we have subclauses within that section typically. There's going to be a section on the residue or the residuary estate. And this is a longer discussion about what is the residue of the estate, but that's the meat of the estate typically. And it's going to break down who is getting what. And oftentimes in a will, when we open it up, that's the first place that we're looking to, is what is the residue of the estate, because that's the crux of the issue, is all of the stuff aside from personal property becomes the residue of the estate. There's likely going to be an article on remote and contingent beneficiaries. And then there's administrative sections such as general administrative provisions and designation of personal representative. And the personal representative you've heard us talk about earlier is the executor. That's another term for it in Oregon. Then there's going to be sections on powers of the fiduciaries, provisions for payments of taxes, and additional definitions and general provisions and additional clauses. So this is a broad outline about what a will would look like. There's, depending on what is anticipated, what is intended, there may be more or less sections. There certainly can be no contest provisions to try and prevent infighting. But this is a broad overview about the types of things that are included. This is not intended to be an exhaustive list. This is only for informational purposes, and if you have further questions, please do talk to an attorney. Don't try and prepare this on your own. As we've explained in previous videos, this is a very important document because if you don't execute it correctly, then your will isn't going to be done. It's very possible or likely even that the person or persons that you're intending to pass property to or charities may not be able to receive the gifts that you're trying to bequeath to them because it's not executed properly. So please do talk to an attorney if you have further questions. This is Blaine Cluten for Cluten Law. Thank you.